Hello and welcome back to my channel Course and Now. Today being the Monday, and as usual, I normally prefer to speak in Hindi from Monday to Friday and have chosen to upload the video on Saturdays and Sundays in English. But I'm deviating from that practice today for a specific subject which is in concern I'm going to discuss. The issue in context which I'm going to deal here with is a patent and the copyright. I'm not going to deal with in depth about the law per se, but I'm going to discuss about an incident which has been reported widely in the media, the print media rather. I'm sorry. Now, so we all eat food. We all go to the restaurants. We all go to the five-star restaurant, those who can afford it. For any food industry or for any hospitality industry, the role of chef is very important because he is the master of recipe. What if the chef starts applying the copyright or, for that matter, a patent for his recipe? So that's the context. And what if we in a day-to-day life are coming across with various software products? Every day thousands of coding is happening by using algorithm or the technology, which I'm not expert, but I'm just trying to say something on that, whatever little I know. So what if the softwares are patented? What will be the consequences? That's the whole premise of this discussion. You see, if the chef would like to protect his recipe by applying for a copyright of the recipe, then obviously the recipe which has been copyrighted cannot be used in context of the same food. To say that the copyright protects the written recipe and not the idea. You can make similar dish but cannot publish the chef's recipe as your own. For example, say a particular chef has its recipe copyrighted for a particular food or particular dish. Now another chef can make a similar dish or an identical dish, but he cannot claim that as his own dish, as the recipe happens to be already protected under the copyright. So he may prepare the same dish or an identical dish but can't claim as its own dish. That's the because it's already been protected by way of a copyright of a chef who has already received a copyright of his recipe. So that's the area of a comparison with the software patent. Now, at the most, we all know that softwares can be copyrighted. What can be copyrighted is a coding by using the algorithm. That is permissible as a copyright for the patent. for the software product. But you cannot patent it by using any code or algorithm as a new idea or an algorithm itself. For a patent to be for a product to be patented, it has to be an idea, innovation, a new idea, innovation. That's the bottom line. So what has happened recently, a public policy director of a free and open source software foundation, in short it is FOSS, FOSS Foundation, its director Mr. Venkatesh Hariharan declared one such patent granted to software by an Indian patent office as an absurd. And he went on saying that granting a patent to a software is a very, very, very bad idea. Rather, it is a ridiculous application which was granted of a patent by the Indian Patent Office. Here what has happened is this. There was a patent applied for a software code which was in a way was a well written legal document, but there was a twist. It begins by explaining the drawback of the existing voting system, and it went on describing as a novel feature of an invention, and that is in verbatim. I'm going to explain what it has described as a novel feature of its invention when they applied for a patent protection with an Indian Patent Office. The description goes in verbatim as: voting will be free and fair, transparent, and no doubt on this online process by tracking method of our vote cast. After declared result, the voters know about their vote cast, which candidate to got it. Voters could be voting from anywhere in the world at the date of the cast of the vote. Not to make anyone stand in the queue for voting. This is what the basis of description which claimed to be a novel feature when the patent application was applied by this person who wrote this code by using an algorithm which is a software. And Indian Patent Office eventually granted him a patent for this particular innovation. I don't know why, but it was granted. That is how the first director said, see, this is particularly bizarre. This is going to be an absurd idea. This is a very bad idea and it should not have been granted. And he gave a parallel of the chef. That's how I began with the explanation on the recipe prepared by the chef and what if he copyrights it. So that is why the beginning of discussion was with the chef's recipe. Now you must have understood why I was drawing the analogy. Now what he was trying to compare is that in the software era, the copyright protects the specific code, how that algorithm is being implemented, but not the underlying idea or an algorithm itself. Like in food industry or hospitality industry, a recipe prepared by the chef, he may get the copyright of that particular recipe, but not as an innovation of the recipe. Then if that happens, then it will lead to a bizarre situation. Now suppose an idli recipe is been copyrighted to say to someone X person, and if some other chefs prepare the idli, he may prepare the idli or any sambar or any other dish which he wish to prepare. And if there is already an existing protected copyright recipe with that particular dish, then he will not be able to claim the inventor, or he may not be able to claim the owner of that recipe, but he can certainly be allowed to prepare some dishes and identical dishes. So like in software also, by using algorithm and coding, you may prepare various software which may or may not be identical, but which may be similar to other product and all. Like there are so many platforms, online selling platforms. The coding may be some or less different, maybe by using some other methodology. The algorithm may be described in such a way, or coded in such a way to give a different product. But the whole idea of all those platforms are not an innovative idea. That at the most particular coding is the copyrighted product, but those coding cannot be patented one. So patent is for an innovation, which is a new idea, a fresh idea, new innovation, new research. So that is how if such kind of products or software products are granted patent by an Indian patent office, it will be only an absurd idea or bad idea. That's what the main contention of the director of the FOSS. Now, he went on giving an analogy of the shape with an intention. Suppose if the recipe were patentable, a chef could potentially monopolize a particular combination of the ingredients of cooking techniques, preventing others from creating similar dishes without permission. Then that situation would not be an ideal situation. That is what the comparison was when he tried to explain with the chef's analogy and the recipe. And then he went on to compare with the software product and its copyright, and why the patent should have been avoided. Mr. Hariharan then points out that why the FOSS model, that is the free and open software foundation, that is FOSS model, is critical for India and eventually the Indian Patent Office. He goes on explaining the Linux Foundation, a leading FOSS organization, hosts 300 plus FOSS projects. The most recent estimates have valued the project it has created using 1.15 billion line of code at the rate of 54 billions. Similarly, the Aptech Software Foundation estimate that 350 plus projects it holds have created FOSS worth 22 billions. These projects cover the most fundamental technology from cloud computing, distributed computing, big data analysis, blockchain technologies, and many others. The software prowess India acquired over the last few years was on the back of riding software built elsewhere. But now India has built its own power and is making presence felt all over the world. He suggested we imagine a world 10 years out. What if the software giants such as TCS, Infosys, Wipro and other leading companies which are full of smart people start patenting their work? Now, that is how he was very worried. The most of us have come to take for granted. It is patented and the creators can insist every Indian company that uses it must pay to deploy it. The outcome will be a geopolitical battle. That is when it will go and hurt, rather it will begin to hurt. This is why it is in India's long-term interest to stop dishing out absurd patent, the like one which is granted in a case where the Indian Patent Office granted a patent to the software which claimed to be an distinguished product, a distinguished coding, which is used for a particular elections. At the best, what could have been granted was a copyright of that particular software, but not the patent. Now, that is what a dangerous analogy. If the Indian Patent Office does not distinguish between what can be patented in the software and coding industry and what can be patented in the software industry and what cannot be, rather I should say what can be copyrighted and what should not be copyrighted, then there will be a big problem. The software needs to be copyrighted and not patented, because the idea has to be innovative and distinguished and fresh idea, and the software as such which is written by using codes or algorithm as such could at the best be copyrighted, because algorithms cannot be patented, cannot be copyrighted. That's it. Thank you very much for watching this video. I shall come back again with a different subject on a different legal issue in coming days with the videos, and I shall see you again. Thank you and have a nice day.